Let's move to the next case, Jones Family Trust versus Saginaw County Land Bank Authority.
Good morning, Your Honors. May it please the Court, I'd like to reserve 2 minutes for rebuttal.
That would be fine.
Thank you. Your Honors, the issues here today all fall back to a house next door to my neighbor's house striking theirs when the demolition of the blighted house was occurring. That blighted house was owned by the Saginaw County Land Bank. In order for I believe, for the appellees to win in this particular instance, they're going to require this court to overturn 2 rules that have been established for this court since at least the 1800s, which is one about the issues of taking under Parsall, which was later adopted and very clearly in Tome, as well as the rules of contract damages, which is different than tort damages in this particular case. I would just like to point out the case, I think, for the takings part, to quickly get to that. I think that the Tome case versus State Highway Commissioner establishes a very clear standard for what constitutes a taking. And I'm just going to read it. It's 3 sentences. It should not be, the term taking should not be used in an unreasonable or narrow sense. It should not be limited to the absolute conversion of property and applied to land only, which is what we have here, not land only. But it should include cases where the value is destroyed by the action of government or the serious injury is inflicted to the property itself or the exclusion of the owner from its enjoyment or from any of the appurtenances thereto. That's what we have here. We have an instance where the neighboring property owned by the government flew out of control, crossed the property line, and struck my client's property, causing complete damage, according to the expert's report that we've obtained in this case. So I think we clearly have a taking here. And the theory that I've used is under the destructive forces claim shows that you don't even have to be the one swinging the hammer at the time. You can start the process going forward to be able to cause that damage when you're the owner of the property. The defense, I think one of the things that wasn't highlighted very carefully between the parties as part of the voluminous briefing with this particular court, is that the appellees seem to suggest, the land bank seems to suggest, that just because it was the city was the one that took a contract to essentially act as a subcontractor, that somehow its constitutional duties transferred from the land bank to the city. I have searched this court's jurisprudence to find an example of where that's either been allowed or not allowed, and there's nothing. I have found absolutely nothing. The closest we have is the Court of Appeals decision in Estate Development, which cited to the Sherlock case out of Alabama, and that is Sherlock versus Mobile County, which basically holds for the proposition that when there is a duty under the law, you can't delegate that duty to a third party. You can insure against it. You can buy insurance. You can require a bond. You can make the financial obligation someone else's responsibility. What you can't do is waive your particular duty in that instance.
But to look at the language of the Peterman case, I mean, what conceivably occurred here on the part of the Land Bank Authority that either set into motion the harm that eventually transpired here? What was it that reasonably forewarned them of the prospect that that harm would eventually occur? In what sense was it the natural and direct result of what they undertook to do here? I mean, these are the standards that Peterman seems to be establishing here, and I'm just hard-pressed to understand what it is that the Land Bank Authority did that can be fairly said to have satisfied these kinds of standards for imposing liability upon them.
Well, the problem with that assertion is that there's an underlying, I think you're an underlying implicit assertion that there has to be some kind of intent or some kind of invoking of some sort of action on behalf of the public body.
No, I think some of these can be triggered by what a reasonable person ought to know about what they're setting into motion or what they're causing to occur, and I don't know that there has to be an actual intent.
Well, then that's the case here, is that however, a taking is a unique definition of a unique aspect or principle under our jurisprudence. As I just read from Tome, it doesn't have to just be out there, the actual land bank swinging the hammer and causing the damage. What it has to be here is that if it causes the damage, not if they intended to cause the damage in this aspect. And that's what causes a loss in this respect, and it causes a harm that was specifically bore completely by my client. This wasn't a case, for example, the Blue Harvest case, for example, that my opponent cites quite regularly. That was the salt on the road. That sprays to everybody's property. Everyone suffers that equally just by the substance of being along, or the natural being of being along a public roadway. Here, my client had a piece of property. She did nothing wrong in any of this. She didn't cause the land bank to demo the building. The land bank, for example, could have rehabbed the building. They could have taken a lot of different steps. What they did is they started the process that started the demolition of that particular building, and that demolition directly resulted in loss to my client in the form of diminution of value for their house that they were living in.
Because I guess my question is that I guess I hear your argument, but I guess what I'd like to have a better understanding of is that isn't it a little bit attenuated though? I mean, the land bank isn't the entity that's responsible for demolition. The demolition is basically solely directed by the city.
Again, I would point to my argument that I started out with here is the land bank is the owner of this property. You cannot transfer your at least it's my position here today, and I would ask this court to adopt a rule that says you can't transfer your constitutional duty to another. For example, this court has said a number of times in an example that it can't transfer its duty to decide a case to another entity, right? It's the responsibility that lies here with this particular court.
But what should the land bank have done differently? I mean, the land bank is under obligation to go to the city, and then ultimately it's the city's responsibility to hire road brothers to then conduct the demolition. It's just, the question here is that I'm trying to understand exactly, I guess based off of the chief's question, I mean, I'm just trying to understand how it's just not totally attenuated, and I guess your position would be that the land bank could have done other things like rehabbing the property or doing other things with the property, but it was their decision to demolish the property. But wasn't it the land bank's, doesn't the land bank have to demolish the property? Am I understanding this incorrectly?
You are understanding. There is no requirement that they had to demolish the property. They chose to demolish the property. They could have rehabbed the property. They could have fixed the property. It was a house that was there. The standard here, I guess, is that, and I guess what I'm hearing here is what foreseeability did the land bank have, and that one of their subcontractors would eventually cause damage. That's not the standard under a taking. The standard under a taking, again, I point us back to Tome. That first paragraph in Tome is if you cause the serious injury. It doesn't matter whether you intended to cause it or not. It's whether you did cause it. And in this instance, they did cause that through the application of their subcontractors in this particular case.
It wasn't their subcontractor, it was the city.
Well, my position is that the Rohde, and I addressed this in the brief, is that I believe that the Rohde brothers is the subcontractor of the land contract. It was the land contract entered into a subcontract with the city, and the city in turn re-subcontracted it out to its individuals. What we have here
Weren't they obligated to go to the city? Like, isn't that the obligation? They're not.
They are not. This is a purely voluntary, unique program created in Saginaw because Saginaw had access to blight dollars. The land bank had blighted houses. They joined together. And that's, I think, one of the big misconceptions, that they are obligated to do this. This is a voluntary action on the part of the land bank to do this particular aspect.
So the land bank doesn't have to go to the land bank could have done this without having to involve the city?
Correct. The only reason why they went to the city was because the city had federal blight dollars through what it's called neighborhood stabilization. It's TARP money. It's original TARP money that was first made available under President Bush to help revitalize neighborhoods.
I see.
So that's my position, is that simply kind of kicking the can to somebody else and saying, we transferred our constitutional duty not to cause harm to somebody else, is unsustainable. And in fact, there's no case law they have cited to support that. The case law that I would cite to this court, again, is the Sherlock case, and then also the Court of Appeals actually dealt with the non-delegation duty of obligations that are imposed on governments, and it comes from a sidewalk case. It's Figueroa, Figueroa versus City of Garden City, 169 Mishap, 619 at 623. You can't transfer that constitutional duty. You can ensure the financial effects of a screw-up, but you can't transfer the duty or delegate that duty itself. And I would ask this court to say the buck stopped with the land bank. Now, ultimately, because they entered a contract with somebody else, what should have happened and what I expected to happen, because I'm in the rare instance before you here, usually I'm not trial counsel, I was trial counsel in this case. What I expected to happen was the land bank was to sue the city, and this for contribution indemnification under the agreement. The city would have then sued Rohde Brothers for indemnification. They didn't here. And as I pointed out in my reply brief to the supplement, I think the reason why they didn't was because they were all represented by the same law firm. You can't sue each other when you're represented all by the same law firm in this respect. So turning to Rohde Brothers, who I think has got if the constitutional part doesn't end in the land bank, I think there's certainly liability on the part of Rohde Brothers here. And the problem I have with Rohde Brothers' argument here is that they're asked the trial court to adopt a standard that only applies in negligence claims, not contract claims. And as I point out in my brief to the supplemental brief to this court, if Rohde Brothers wanted to limit their damages in some form or fashion, they had absolute authority and freedom to limit it by contract and negotiation. They didn't do that. The standard here is that we look to place the breaching party back in as good a position as if the contract had been fully performed. The question of damages was rendered by Judge Kazmarek in the Saginaw County Circuit Court as a question of law. Damages has always been a question of fact. That's a jury question or a trier of fact question. This court has gone back all the way more than 100 years. That standard has been identical. It's actually one of the most bedrock principles we have, and I think Michigan jurisprudence is that we put you back in the position from where you were at. My client had a code-compliant house at the time. Now, when I say code-compliant, she had the right, and I say she, my main client is the trustee of the Jones Family Trust. She had a house that was covered by the doctrine of nonconforming uses. This house was built in the 1860s. She was compliant at that particular time. When Rohde Brothers destroyed that house and it requires a complete renovation, fix of that, she now has to make it up to the standards it is today, the current codes right now. So when Rohde Brothers destroyed her house, they didn't just destroy her house, they also destroyed her legal right that she had to the doctrine of nonconforming uses for her particular house. And so to get us back to where, again, the standard is to place the breaching party in as good a position as if the contract had been fully performed, requires them to put them back to a code-compliant house. And in this particular unique set of facts, it requires a house that was probably better than the one that was there. Unless the city has, unless Rohde Brothers has some way they can get those nonconformance rights back in some instance, which I'm not aware that can happen. This is where we're at. And I think and I'm not asking, I guess as a final point is, and I know I've argued this before in this court, I'm not asking this court to rule that they are entitled to that money. What I'm arguing is they're entitled to the right to present that information to a jury and let the jury decide that as a question of fact. Unless the court has any other questions, I'll reserve the balance of my time for rebuttal.
Okay, thank you.
Thank you.
Good morning, Chief Justice, esteemed justices. May it please the court. I was going to go ahead and just waive my initial no-shot time, but I think there's a couple of points I'd like to briefly address, and then I'll be happy to open up to questions for any other matters. One of the things that Justice Bernstein asked about was with respect to the voluntary actions of the land bank and whether they did or didn't have to do this. One thing we need to look at is that this house that the land bank owned, adjacent to the appellant's house, was found to be in violation of the dangerous building ordinance. The dangerous building ordinance is enforced by the city in their code and department. They then determine what has to be done with that. That is their power, that is their right. So with respect to this, yes, the land bank owns properties and they work in conjunction with the city to be able to determine how best to resolve and eliminate the blight. However, this is a situation where the city was enforcing the dangerous building ordinance. So we're talking about a matter where it's not that the land bank could have not worked with the city, could have done whatever they want. They were required to go with the dangerous building ordinance and be able to resolve it in that way through how the city enforces that. Once again, we're then back to the fact of this MOU, Memorandum of Understanding, with respect to the not being able to contract away certain duties. That's not what did here. The land bank didn't try to contract away any kind of potential eminent domain duty it may or may not have, its duty to provide just compensation. It hadn't entered into an agreement with the city through the dangerous building ordinance enforcement, so that the city could be able to agree that they would take the responsibility to control all the demolition factors, to coordinate all that. There's a direct line of duties that come in. What I think is interesting with this is we're talking about a situation where the city was a defendant to this case, and they were voluntarily dismissed with prejudice by the appellants. If that's the situation and the land bank being far attenuated from any kind of action regarding the demolition or any kind of potential taking is culpable, then why didn't we think enough to keep the city in? Well, that's because the fact that the land bank is clearly too far pressed away from any kind of action with this. I do want to clarify, too, it's not our position as the appellees to say that there was potentially no taking or that there wasn't any kind of issue that may require just compensation. It's the matter of the fact that the governmental entity at issue, the land bank, did not carry out any affirmative actions directly aimed at the plaintiff's property, which is required for the takings clause and the just compensation. On top of that, we're also looking at a factor of that these appellants then decided to leave their home. They voluntarily left it unheated for the entire winter. And so we're now in a situation where we're looking at the causation and the incidental aspect of damages. And I don't want to belabor this court with the facts into that unless the court would like to get into that. But I would like to say we're looking at a situation where any incidental action by the land bank, which is merely owning the house, is really the situation we're looking at. Anything beyond that is far too attenuated to be able to connect to them saying that they accomplished a taking as opposed to any other governmental entity involved. I also just briefly want to address the breach of third-party contract issue. We're in a situation here where I don't disagree with brother counsel's arguments. I don't disagree with the contract standard of putting the person back in the position had the contract never been breached. But that's not what appellant's asking for. Appellant's asking to be placed in a better position than they were. They're asking to be unjustly enriched. And oh, by the way, the aspects about code enforcement and these code violations, bringing it up to code, the Rohde brothers never forced them to allow their house to go in violation of the codes. That wasn't their situation. The plaintiffs could have, or the appellants could have done whatever they needed to do throughout the ownership of that house to bring it up to code. So we're not looking at a thing where not only is the measure of damages limited to a specific standard held by the court, but we're also looking at a factor of that they want us to unjustly enrich them and allow them to benefit from their own violations of not keeping their house up to code. But ultimately, we get to this thing about measure of damages versus damages. There's no question that damages are determined by the trier of fact. You provide the evidence, they get to make their determination based on what they have. The courts have been very specific, and I think this court would agree, that the measure of damages is different than damages. I think we're getting into a semantics battle here a little bit. The measure of damages is an instruction that the court provides to the jury for how they determine and calculate those damages. The case law, including this honorable court's holding in the Gustav case, which I think was back in 1912 and is still good law, is a matter of the fact that it's a matter of law for the court to determine the correct measure of damages. They instruct the jury on that, and then the jury gets to be able to determine the amount of damages based on that measure. With respect to this case, I did a little bit of background research, and I'm actually looking at this in the sense that I think the Price v. High Point Oil case took what was traditionally more of a contract standard and expanded it to a negligence standard. Because if you look at the contract cases that detail with the same type of measure of damages, which is you get either the cost of curing the defect, or you get the amount of the property that was tendered versus the amount of the property that you're actually supposed to get. We're looking at the exact same measure of damages, which, in practicality, places the aggrieved party in the position they were had the contract never been breached. In that sense, we're looking at a situation here, not whether it's $350,000 to provide them a brand new, beautiful, bigger, better, and faster house than they had before. We're looking at a situation of what did the Rohde brothers do? What was the value of the property? There's no question that the cost of repairs exceed the value of the property, and that's been conceded by the appellant. So we're looking at a situation where now we're looking at, okay, how much was the property worth that they had versus how much was the property worth that they would have had the contract never been allegedly breached. The value of the property they had would have been fair market value for a house in the city of Saginaw that's over 200 years old with all fraught with code violations. What they tendered was what they have now. They're claiming that the house is worth nothing. It is worth noting that as part of the consent judgment, in order to get eventually to this point of the court, there was a settlement reached and there was $20,000 paid. I think that's more than fair for the just compensation for that type of house. So we're even looking at a thing that if this does get sent back, we're looking at a matter of where are the additional damages at this point. The measure of damages is going to be the value of the property. That's what's going to curtail the damages. And there wouldn't be any expectancy on the part of the Rohde brothers when they entered in the contract with the city that they would have to pay for code violations that they never committed in the first place that were the result of another owner. In this sense, we're just reaching way too far beyond the contract principles to get to there. Like I said, I think actually it looks like the Price v. High Point Oil case more adopted its kind of ideas more from a contract kind of perspective, and I think that puts us right back in the place we have. And I think it also establishes that the Court of Appeals and the trial court were correct, and we request that the court peremptorily affirm both those rulings. I am open to questions for the remainder of my time.
Counsel, I guess the question is, is it your contention then that the trust is put back into the position they were before the demolition took place? Ultimately, brother counsel is arguing that they've got to be put into the same position that they were in. They didn't do anything wrong. Their house got knocked down. So there wasn't anything they did. There wasn't any actions that they took that led to this. So I guess, is that settlement then, would it be your contention, putting them in a place that's equal to the occurrence before it happened?
Yes, Your Honor. Yes, it would be. It would be fair market value for that house. It's technically the difference in fair market value before and after the strike. However, for the sake of this argument, what we're talking about, we'd say it would be the value of the house prior to the demolition, and then the value of the house after the demolition, which, to accept all allegations from appellant as true, would be zero. So it would be the fair market value of the house would be the position they had the roof never contacted their house. They would have had the same house they would have had going through that continued to be over 100 years old and continued to be fraught with code violations.
And what is your response to his argument that the land bank did take an affirmative step by determining that the house had to be demolished?
Well, and Your Honor, I appreciate you asking that. That's actually what I addressed at the beginning, was the fact that the determination for demolition was done through the enforcement of the dangerous building ordinance. That was something that the city decided to do, and the proper measure. If the land bank was just merely having, the land bank has other properties that aren't necessarily in violation of the dangerous building ordinance. But in the sense we're looking at here, in the enforcement of the dangerous building ordinance, based on the state of that property, it had to be demolished. This isn't a matter of end running, the federal grants and things to be able to get money to demolish it. This is the thing where we're looking at a situation where the federal block grants are used exactly what they're supposed to be used for, which are given to the city. The city uses those to be able to demolish these properties that pose a danger to the area, not just to eliminate an unsightly house, but that pose a danger. The city and the code enforcement agency and responsible for enforcing the dangerous building ordinance, their duties are to protect the health, safety, and welfare of the community and the neighboring properties.
So just to understand the argument is that the land bank, your argument is that this was the city's decision and not the land bank's decision because of the code violations?
Well, I want to make sure we're correct. When we're talking about code violations, are we talking about the violations to the blighted property under the dangerous building ordinance?
I'm just trying to understand. Yeah, I'm just trying to understand your argument. Your argument is that the city basically was the entity that made the decision, not the land bank.
That's correct.
And so what role did the land bank play in this?
They were the owner of the property.
And your contention would be that other than being the owner of the property, the land bank played no role in taking any kind of action?
Played no role in directing any affirmative action that would have resulted in the damage to their property, which begins and ends with the enforcement of the dangerous building ordinance and the resulting demolition.
So is it your contention that the land bank this is just what I'm trying to understand, that the land bank they were not the entity that decided to knock down the house? I'm just trying to understand exactly what your contention of their role would actually be.
My contention of their role is they're the owner of the house. They were notified that it violated the dangerous building ordinance. They agreed and basically said for the city to be able to carry out what it needed to carry out. In that MOU, there's two paragraphs that I quoted. One was directly related to demolition, but the other one was directly related to repairs and rehabilitation. They work with the city for the city to determine, for them to determine how best the city is going to carry out these actions. But to even make a determination, what they basically said is, yeah, we're in the violation of the dangerous building ordinance. We need to do what we need to do to be able to protect this property.
And I'm not trying to be difficult. I'm just trying to really understand this. Who made the decision? Who gave the order? Who said this house should be knocked down? What I'm trying to understand is you're saying this was like a consensus that was reached between the city and the land bank, or did someone at the land bank say, let's do this, we should knock this down, or was it more that the city told the land bank we should knock, I'm trying to understand specifically, like, when a decision was made that this was the action was going to be taken, who made this decision?
Well, Justice Bernstein, I would say that would be the city, because it all stems from the fact that the city determined it was in violation of the dangerous building ordinance. So from that point forward, the city has certain obligations on the dangerous building ordinance. They do have, I'd say, an agreement to determine what best to do with the properties and how to facilitate it. But no, I don't think the land bank was the one who said, yeah, demolish it as opposed to rehab or anything like that. The city has an obligation under the building ordinance to carry out certain actions, and those are determined based on the state of the house. I'd say what the land bank would have done is to tell them, yes, verify, yes, these are in violation, yes, these are problems. Yes, for what we're looking at, it would likely be more economically feasible to demolish it as opposed to attempt to rehab it.
So then other than basically owning the property, it's your contention that the land bank takes its order from the city?
Well, no, I'm not saying that are you talking about like if the city says, yeah, we're going to demolish it, then the land bank...
That's what I'm trying to get to. It's just like this, in the kind of the cascade of events, was it the city that said, we have problems with this house needs to be demolished, and the land bank was then passive, and their role is just to kind of go along with it? Or was there a meeting between the city and the land bank, and the city said, yeah, there's all these problems with this house, and the land bank says, oh, yes, you're right? I'm just trying to understand exactly what role each entity did in terms of the decision-making that set this in motion.
Certainly. I would say in that sense that the land bank would have been passive. I mean, they would have been in the situation where they're holding the property, and it would have been no different than another property owner telling, to the city's going to another property owner saying, hey, this house is in violation of the dangerous building ordinance, and we have to enforce our actions to be able to take care of it. And that owner, I'm sorry, my time.
No.
The construction of your answer is confusing though, because I would say that the land bank would have been. Can you just tell us what the record shows, not what you would?
Oh, I'm sorry.
I think Justice Bernstein just wants to know what the record.
Right, I just want to understand.
Go ahead.
No. I'm just trying to understand the nature and scope of relationship and who is involved in the decision making of this.
Okay, well, interestingly enough, to address both Justice McCormick and Justice Bernstein's questions at the same time, the record would indicate that I think the best evidence at this point is the MOU. There were no depositions taken, I believe, I don't believe we had any of the building inspectors or anything testify about their roles and what they did to make that determination or any meetings behind closed doors. It's relying on the MOU and the obligations that spawn from that.
Is this a question of fact now? I mean, is this something that maybe needs to be fleshed out? Like, I guess the question is, because I think it's a little ambiguous and uncertain, do you think this now rises to something where basically this is a question of fact as to how this decision was made?
No, Your Honor, I don't believe so. And the reason is because we're still looking at the fact that even if the land bank was the one who said, yeah, and to enforce the dangerous building ordinance, you're right, we have to go ahead and demolish this building. It's the situation that the city was the one who was responsible for, one, enforcing the dangerous building ordinance, which would have led to the demolition. Two, the actual every single action that would have been conceivably aimed at that property was carried out by the city. So I don't think there's a question of facts or that a determination of who, if there was an ultimate deciding factor for the dangerous, the demolition, because we're not looking at a voluntary action. We're still looking at something that is initially spawns from the fact that this house was in violation of the dangerous building ordinance.
Thank you.
Thank you, Your Honor.
Thank you, counsel. Mr. Ellison, you have your reserved time.
Thank you. To go to Justice Bernstein's question, we've heard in the argument both a concession and some confusion. He conceded that he did not transfer the constitutional duty to be responsible not to cause damage to the property. He said that earlier, and then later on said, well, it's the city that ordered us, or at least implied the city ordered us to knock it down. There's a process under the dangerous building ordinance for when a building needs to be knocked down, and none of those hearings occurred. The land bank worked with the city and decided to enter into a joint agreement, a joint operation to voluntarily knock this property down. And what's key here is that had the land bank not started that process, there wouldn't have been damage to the Jones Family Trust house. If they had not started the chain of events that caused that roof to break away and strike my client's house, none of this would have occurred. This is why Peterman's important, because Peterman, if you remember, is the case where they installed jetties and they installed some riparian land structures out, boat launch and that nature. And later on, it caused damage to the property as an unintended consequence of starting that process. That's the same thing here. They started a process where the consequence of that caused extreme loss of their whole house to my clients. It's the same story with Peterman. And so I would argue that we can't have it both ways. You can't say it's the city's obligation, but at the same time say we still retain the constitutional duties that we have under the just compensation.
Why did you dismiss the city?
I'm sorry?
Why did you dismiss the city?
Because the position of the city at that particular time was that it's the land bank's fault in the lower court record. And it was the same law firm that made that same argument. And so to narrow the scope of the issues that were there, we voluntarily dismissed the city from the suit. Because the one that had the constitutional duty, the obligation not to cause damage, is the owner. Thank you.
Thank you very much, Mr. Jordan, Mr. Allison. Case will be submitted.